Welcome to the Disability Granted channel. I think most of us approach Social Security disability with a negative attitude, at least at first. We don't like the forms they give us. That includes an adult disability report, an adult function report, a work history report, as well as an application. We have to give them an authorization to disclose our confidential and personal information. Why do they need that? You know you're disabled. At least that's what you believe. But you need to ask yourself, am I disabled? By law, you're not disabled until you prove it by the greater weight of the evidence. That's the way it is. You probably have assumed that Social Security has the burden of proving you're not disabled. So what do you have to prove? And what is Social Security disability? Unlike other disability programs, Social Security doesn't have temporary disability. It doesn't have partial disability. It doesn't have permanent partial disability. Social Security has no 10% disability, 20% disability, 30% disability, and so forth. Social Security is total disability. In its Red Book, Social Security defines disability for us. It tells us, to meet our definition of disability, you must not be able to engage in any substantial gainful activity because of a medically determinable physical or mental impairment or impairments that are either expected to result in death or have lasted or are expected to last for a continuous period of at least 12 months. That's their definition. All right, they use the magic term substantial gainful activity. That is a Social Security term. Generally, for 2023, earnings over $1,470 per month are considered to be substantial gainful activity for SSDI. For SSI, Supplemental Security Income, substantial gainful activity is countable income equal to the federal benefit rate. That increases every year with inflation. Next year it'll be more, and the year after that, substantial gainful activity will be higher. Here's something you need to understand. Social Security has no burden of proving you're not disabled. By law, you're not presumed to be disabled. You have the burden of proving your disability. Social Security doesn't have a burden to prove you're not disabled. You need to understand that. Until you're determined to be disabled by Social Security's 5-step evaluation process, you're not disabled. As a matter of law, you're not disabled. No one has to prove that you're not disabled. You need to understand that. It also changes your point of view and your perspective and your focus on where you need to be, where you need to go in the application process. And once you realize that you have the burden of proving disability, you understand that you're not disabled until you prove it. That's one reason not to believe phony stories about how Social Security spies on Social Security applicants, how Social Security pays off consultative doctors to prove you aren't disabled, and how Social Security hires private detectives to secretly film your activities, interview your neighbors, and try to get into your house as evidence to prove you're not disabled. You're not disabled until you prove otherwise. Scaremongers and misinformed persons perpetuate such misinformation. Even authorities advance it. There are authoritative resources on the internet that spin the narrative that Social Security is out to get you. Disability Granted will soon review such an online article in a coming video. Are they watching you? Don't be distracted by such nonsense. Social Security doesn't have to prove you aren't disabled. You must prove you are. You have the burden of proof. Until you prove you're disabled by the greater weight of evidence, you're not disabled as a matter of law. So how do you prove you're disabled? I mean, you want to know how to prove you're disabled, right? Social Security Disability tells us that it uses a 5-step evaluation process. It uses the same 5-step evaluation process for SSI that it does for SSDI. You have the burden of proving by the greater weight of evidence each of the first 4 steps. The government has the burden of proof only in step 5, after you have carried your burden of proof in the first 4 steps. So, what are the steps? What are the 5 steps in this evaluation process? Step 1, are you working? Until you prove by the greater weight of evidence that you're not performing substantial gainful activity, Social Security cannot consider you have a qualifying disability. Remember, generally, earnings over $1,470 per month in 2023 are considered to be substantial gainful activity, and that amount does increase every year. So the threshold will be higher in 2024 and 2025 and so forth. Now, most of the disability determination process is made by disability determination services. The exception, of course, is the hearing before an administrative law judge, but step 1 is not made by disability determination services generally. It's made by your local field office. If you prove you're not performing substantial gainful activity, your case is sent to Disability Determination Services for determination concerning your impairment or impairments. Be warned, your application will be denied if you return to substantial work before disability is established. Next, step 2. Do you have a severe impairment? If you're not performing substantial gainful activity, you must next prove that you suffer medically determinable physical or mental impairments. You must prove you suffer one or more medically determinable impairments and that those impairments are severe. An impairment is considered severe if it significantly limits your physical or mental ability to do basic work activities. Be warned, if you have an impairment resulting from drug addiction or alcoholism, expect your application to be denied. Next, step 3. Do you have an impairment that meets or medically equals a Social Security listing? We have the adult table of listings, and they list impairments. They categorize impairments, and they categorize how to prove them. And if you have the medical documentation, the medical test, medical diagnoses, and you have sufficient other proof, this may qualify you for disability, just meeting those listings. Step 4. Are you able to do your past work? If not, you have the burden of proving whether, given your residual functioning capacity, that's a Social Security disability term, that would be your remaining abilities to work. Given your residual functioning capacity, you are physically and mentally unable to do any job you did in the past. Generally, that's 15 years. As step 4, you must prove that you cannot do work you did in the past. That's important. If you can do work that you did in the past, they're going to say you're not disabled. Now, before we go further, you probably want to know, what is residual functioning capacity? When it comes to Social Security disability, you get terms, and more terms. Social Security tells us, ordinarily, residual functioning capacity is an assessment of an individual's ability to do sustained work-related physical and mental activities in a work setting on a regular and continuing basis. A regular and continuing basis means 8 hours a day for 5 days a week, or an equivalent work schedule. Now let's move on to the 5th step. Remember, you had the burden of proving the first 4 steps. You prove those first 4 steps, you're disabled unless Social Security can prove step 5. Social Security has the burden of proving whether you can do any other kind of work in the national economy. If you prove steps 1 through 4 of the sequential evaluation process, you will be determined disabled unless the government proves by the greater weight of evidence that, considering your residual functioning capacity limitations, vocational factors such as age, education, and work experience, and work existing in the national economy, that you can perform other work that exists in significant numbers in the national economy. If the government carries the burden of proof, you will be found not disabled. Remember, Social Security has no burden of proving anything until you prove the first 4 steps of the 5-step evaluation process. No one has to spy on you or trick you to prove you're not disabled. You're not disabled as a matter of law until you prove otherwise. It's important that you provide a full, complete medical record. Yeah, it's important that you provide a full, complete medical record. Your disability examiner is tasked with compiling your medical records. But do you want to rely on him or her to gather your medical record? After all, you have access to all your medical records. You're familiar with your medical treatment and diagnoses. You know your medical history. You know the names of your doctors, clinics, and hospitals. You know what medications you take. You're aware of their side effects on you. You know your medical history. You know your providers, and you can get your medical records. Why rely on a stranger to get that? A busy stranger. Disability examiners are very busy. Do you really want to rely on them to get your medical records? Because I will tell you one thing. If you don't provide them, you may be denied at the application level, and when you get that notice of disapproved claim, it's going to show what medical records that they considered in determining that you're not disabled, and the important ones won't be on it. You know what the important records are. You know all of your medical record. If you really want to win and win as soon as possible, provide your medical record. Before I go further, you're probably thinking, well, I don't know how to provide my medical record. When you can go to your doctors and say, look, I need medical records for Social Security. And Social Security should contact them later. If you list all of your medical providers in your application, if you list their addresses, their phone numbers, and what they treated you for in your application, other documents, then the disability examiner should have that information. But do you really want to rely on them to get the information you need to be approved as disabled? Authorizations to release information can be provided to each of your healthcare providers. These days, you might be able to get your full medical record online. A lot of healthcare providers use programs such as Epic, where everything is even organized. You can, if you want to look at tests, you go to test, you click it, and it shows all the tests that you've had. It shows who ordered them, what the results were, shows all your medications. It's different than it was before, years and years ago. So you may even be able to get your medical records online. Most places have a My Chart or My This or My That you can access. Find out from your hospital, find out from your other healthcare providers how to get their documents, how to get them if they're provided online. Make that effort. You don't want to rely on a disability examiner. I'm not being critical of disability examiners, but I know their workload, and I know that they're not always provided the information that they need. Oftentimes it's the applicant that overlooks certain things. Maybe there weren't enough spaces for all the providers or some such thing as that. But for whatever reason, you have to provide all that information in your application in whatever form they ask for your medical providers. You have to provide it. If you have more medical providers than they have spaces, then you use the section that says other remarks. You make sure that they have that information. Now I want you to be warned. Yeah, another warning. You will be denied Social Security disability benefits if you fail to cooperate with your disability determination examiners. If you fail to follow prescribed medical treatment. In other words, you have a disability and the doctor is telling you you got to take this medicine, you got to do that, and you don't do it. If you're not following your doctor's prescribed medical treatment, then Social Security doesn't know if you're disabled because of the disabling condition or if it's because you won't follow your doctor's prescribed medical treatment. You will be denied disability if you choose not to continue your claim, if you abandon your claim. The disability examiner can't get hold of you, you don't respond to the disability examiner, expect that your claim will be denied. I hope that this gives you a new perspective which will help you win disability. Now, you should understand now that the forms provided to you aren't meant to question your disability. They're intended to help you prove you're disabled. At the application level, these forms include the Social Security disability application, an adult function report, an adult disability report, a work history report, and an authorization to disclose information. There are not hundreds of forms, as some people will tell you. There are not hundreds of forms to complete for your Social Security disability case. It just isn't true. You need to provide those forms, and that authorization to disclose information, it helps the disability examiner gather medical and vocational evidence for your claim. You want to provide good evidence with your case. Win your case. Don't expect Social Security to win your case for you. There are other forms which you may choose to use. You may think that they help you advance your claim. Among others, they include a third-party adult function report. The adult function report is by you. A third-party adult function report is by a family member or a friend or someone else who is a witness to how your disabling conditions affect you. You may choose to have a statement of a claimant or other person. You may offer treating source statements by your doctors, to have treating source statements for medical doctors, and they have treating source statements for like psychologists, psychiatrists, mental. Don't ask your doctors to send a letter. Letter means nothing. Treating source statements, they're given weight, and a letter isn't going to explain how he came to that conclusion. However, a treating source statement requires a doctor to put that information in there so that Social Security can see what the diagnoses are, when the disability began, how it affects you, how long it's expected to continue. That sort of information. That's what they need. Your doctor sending a letter to Social Security saying you're disabled is worthless. It's a waste of time. If you want to use a treating source statement, I didn't see that they were available online. So you may have to ask Social Security for those forms. And you may ask yourself, can my doctor do these forms? Your doctor's busy. Your doctor may not really know what Social Security needs in the answers to find you disabled. And doctors are reluctant to complete a form which may not help your case. So you may think twice about that. Now, there's something else that you can do. Now, likely Social Security is going to ask you to do a consultative examination. And a lot of people are afraid of them and all of that. You can have your own doctor do a consultative examination. You can request it. And unless they have good cause, they should allow your doctor to do the consultative examination. However, most primary care physicians don't know how to do a consultative examination. And they likely don't have any of the information needed to make one. So you may have to seek out, if you choose, to seek out a qualified vocational doctor to examine you, someone who is qualified to do so for consultative examinations. You may seek out your own physician to do that examination, and they could provide it to Disability Determination Services. It's an option. What do you think? Can you prove you're disabled? Will you prove you're disabled? Do it. Thank you for watching the Disability Granted channel. If you believe this video would help other disabled people, please share, like, and subscribe so that they may watch it. Thank you and good luck.